Now, on Thursday last week, the Senate voted to uphold the impeachment of Rigathi Gachagua as Kenya's deputy president. And the following day, President William Ruto nominated Kithure Kindiki as the deputy president designate. Of course, that went to the National Assembly, who voted for that nomination. Of course, that was before High Court Judge Chacha Mwita issued that conservatory order. Before that was followed by another one from the High Court in Kerugoya, stopping Kithure Kindiki from assuming office, opening a whole Pandora's box of what this means constitutionally for the country. And I'm in studio with the former president of the Law Society of Kenya, Eric Theuri, to just shed more light for us on these issues, even as we wait for the court cases on Tuesday. Thanks, Bonakili, for staying with us. Earlier, we were speaking about how the impeachment was done. Some people saying it was done quite hurriedly, and what that means. And there has been conversations about that 60-day, the 14-day period, and the 60 days that the president has to pick his nominee. And there are people saying that the president may not have flouted any law in terms of the letter of the law, but the spirit of the Constitution raises questions why he did it so quickly. What is your take on this?
The letter of the law is that the president has to do it within 14 days, and then Parliament has to do it within 60 days. Now, let us look at in terms of what it practically means. I think as a country we are in a very difficult situation. Difficult situation in the sense that, one, we do not have an IEBC. And if anything were to happen to the president before the deputy president then gets into office, that will create a bit of a constitutional crisis, considering that the process that led to the impeachment of the deputy president is still in court being challenged. And so I think that if you look at all that and you want to look at the stability of the country and putting the interests of the country at the forefront, there is nothing wrong in the manner in which the process was conducted, because the president did the appointment within the period he was required to do and sent it to Parliament, and Parliament voted as required under the Constitution. Yes, there are people who can actually question the time, the process, and can make arguments that certain processes ought to have been undertaken before the voting was done. But I mean, ultimately, all those are just arguments, and I think that that question is before the court, and the court will be able to look at it and make a determination as to what it is. I think to be a very objective, you have to look at what does the law say, and was there compliance, or what we would call substantial compliance with what the law says, and I think that we are okay with that. So I wouldn't want to comment so much, because now that the case is in court,
yes,
there are other, there'll be a lot of arguments around it, and we would want to see how those arguments will be responded to. But I think that maybe eventually, if the court was to determine this issue, to give clarity around that area. And we must remember, Ben, that as a country, this is the first time we are impeaching a deputy president. We do not have legislation around the impeachment of the deputy president. Yes. We had the same scenario with the deputy governors and how to appoint them, because the law was silent. And sometimes when you find yourself in that situation, there is an element of innovation, and then the court can come out, and actually the amendments that were then done to the County Government Act arose from decisions that the court had made.
Indeed.
With regards to what needs to be done.
I have heard this argument that the Article 145 and I think 150 are self-executing, and that things just, fall in place and there's not much that needs to be done. Do you agree with that?
To the extent that they give practical timelines in terms of what needs to be done, then there's that element. But remember that people will draw parallels. For example, in deputy governors' cases and in cases of impeachment of the governor, there appears to be, there appears to be a process before a deputy governor is appointed. Can that process be said to then apply to the deputy governor, to the deputy president, when there is already a clear constitutional provision as to how the deputy president is to be appointed? So all those are questions, and they are legal questions, and of course, as legal commentators would want to look at it and debate how those issues would want to be done. And the most interesting thing is that worldwide, the law on impeachment is a law, is a process that has not yet obtained general consensus. For example, the question of the intervention by the court is one that has not obtained consensus or general wide practice that is acceptable, because there is an acceptance that the Constitution gives certain safeguards to those who are in office, and that safeguard is the 2/3 majority that is required for the motion to transit from Parliament, and then 2/3 for the motion of impeachment to pass. And so the argument is that once that threshold has been achieved, then the courts should not intervene. But in other places, again, the courts have intervened to look at the process and to give guidance. And so we are in an area where there is really no proper convergence in terms of what the law would be, and that is why you would have a lot of really arguments around this area.
Speaking of which, there are more than 20 cases around this impeachment saga, but if you focus on the latest two, the two orders issued by the High Court in Nairobi and Kerugoya, what would you say is the net effect of that conservatory order by Justice Chacha Mwita? What does it do?
Well, technically, it prevents the final process that is required in the Constitution for the appointment of the Deputy President, designate Professor Kindiki, to take office, because the appointment process ends when he takes his oath of office. And so once he takes his oath of office, then the process of appointment is then complete, and he assumes office. So I think that is what has been stopped. So then, and what I expect then the courts will be looking at, and I foresee a situation where those orders may not stay for so long, is that the court will be looking at the public interest, will be looking at the question, what are the questions being raised? I know the Kirinyaga petition is raising, amongst other issues, the question of appointment of Kindiki, whether, it should have, Parliament should have voted in the manner that it will. And so the court may want to look at the text of the law and the so-called violations, weigh the public interest and the element of the fact that in law we say there is no proprietary rights in a public office, and so if there is an element of any violation, there can be adequate compensation by way of his salary, retirement benefits. And I think that for the Deputy President, his biggest concern right now would be, one, a vindication that he was probably not removed in office properly, but most importantly, that the bar that is placed on him constitutionally against holding public office by way of, as a result of impeachment, is lifted, so that then he can remain relevant politically in the event that he intends to remain in politics.
Again, I've had an argument that's a legal one, that those orders by both courts had been overtaken by events. What would that mean? Do you subscribe to that?
No, I completely disagree. Those orders stop the appointment, the effective appointment of the deputy president, because as my thinking is that it is a process. For example, when the president is elected, he remains a president-elect until he assumes, he takes office. So there is a process, and the process began with a nomination transmitted to Parliament, voted for by Parliament as required, and the final act is the act of swearing in. And so the appointment as of now is not effective. If the appointment had been effective, then the orders would have been in vain, because you cannot stop what has already happened, but you can stop something that is in a chain. Right. And so the correct position is that the orders are effective, they stop the swearing in. But if you ask me, I think that in a proper examination of merit, based on what law we have, chances are that those orders are likely to be set aside, even though the petition is still ongoing, because there's nothing that is going to be lost. Eventually, what is going to happen is that the court may make certain declarations that may in future guide the process of impeachment.